Assalamualaikum and hi everyone. We are from group 6.
So this is our team members consists of Iza Insyirah binti Zaidi, Nur Hazli binti Maknafi, Nur Alia Natasha binti Muhammad Fauzi, Nur Amanina binti Abdul Karim, Nur Ais Adabiah binti Muhammad Maliki, Nur Aina Atira binti Azli, and the last one is Nurul Syarbimi binti Amaran.
Hi, Assalamualaikum everyone. Okay, my name is Iza Insyirah binti Zaidi and my metric number is H21A2104. Today, we are from group 6 and we will present to you about question number 1. Describe the classification and various sources of Malaysian law. What is law? Law is the system of rules which a particular country or community recognize as regulating the action of its members and which it may enforce by the imposition penalties. Okay, next we go to the classification of law. We have a 3 classification. First of all, public law. Second is private law, and the third one is international law. First of all, we go to the public law. Public law is the part of law that governs relations between legal persons and a government, between different institutions within a state, between different branch of governments, as well as relationship between persons that are of direct concern to society. Public law may be further subdivided into 2 categories, which are constitutional law and criminal law. So here, as you can see, this is a type of public law, can be divided into 3, constitutional law, administrative law, and the last one is criminal law. Constitutional law lays down the power of the YDPA, the establishment of the parliament and its supremacy, establish the structure, procedures, powers and duties of the federal and state government, guarantees of rights and liberties of individuals or citizens in the state. And criminal law codifies the various offences and its punishments committed by individuals against the state. The second classification of law is private law, also known as civil law. It regulates the relationship between a citizen and another. It affects the rights and duties of individuals among themselves. This is an example of private law. First of all, contract, trust, tort, company law, and family law. Here, I attach to you the explanation of contract of law. Governs the making of agreements, enforcing it, and provides remedies for any breach of the agreement. Next is trust. Trust of law governs the relationship between a person who holds or controls the trust property for the benefit of other person. The last one is for classification of law is international law, body of law which lays down the principles and rules of conduct by which the states are bound to observe, regulating their relationship with each other. The law which governs the relationship between state and state. It may be subdivided into 2 categories, consists of public international law and private international law. Okay, this is international law about public and private. First, we go to the public. Conduct of war, diplomatic relations, trade and investment, treatment of people, ocean resources, protecting the environment, space law, and to certain crimes. Law that prevails between states. While about the private, international law consists of the rules that guide a judge when the laws of more than one country affect a case. It composes a procedural law such as conventions, protocol, as well as other instruments which regulate the relationship between individuals in an international context.
Hi, my name is Nur Hazli binti Maknafi. Written law have 4 elements in this, which is a federal constitution, state constitution, regulation, subsidiary regulation. First, federal constitution, the power of the federal and state government, the fundamental right of the individual. The federal constitution can only be amended by a 2/1/3 majority of parliament. Constitution can be classified to several categories according to their substance and physical aspect. Literal system that establish the rules and principles by which an organization is governed, a society, party, club, technical and set of rules and principles that define the nature and extent of government that rules the people, the country, state. Next, a state constitution is comprised provisions that are enumerated in the next schedules to federal constitution. Each state has its own constitution regulative the government of the state. Its include matters concerning the rules, the executive council, the legislative assembly, state employees.
Assalamualaikum. My name is Nur Shamimi binti Amaran and my metric number is H2182602. My part is legislation. So legislation refers to laws made by a body which has the power to make laws. For instance, Parliament at federal level and state legislative assembly at state level. Also, laws made by Parliament are applicable throughout Malaysia. Next is type of legislation. There are three types of legislation. The first one is Act, the second type is Ordinance, and the last one is Enactment. For Act, laws made by Parliament after Malaysia independence in 1957. For Ordinance, laws made by Parliament after 1946 but before 1957. And the last one is Enactment, laws made by State Legislative Assembly. But for Sarawak, the laws are called as Ordinance.
My name is Naina Atira binti Azri and my metric number is H2182342. Subsidiary legislation, also referred as delegate legislation, subordinate legislation and secondary legislation. Law made by an authority other than the legislature and the powers given to it by a primary or parent legislation. Subsidiary legislation means any proclamation, rule, regulation, and order, notification by law or order instrument made under any act, enactment, ordinance, or other lawful authority and having legislative effect. This legislation also under Section 3 of the Interpretation Act 1948 and 1967. Next is Parent Act. The Act, enactment, or ordinance that confer power to the relevant authority to make the subsidiary legislation. The relevant authority then makes the subsidiary legislation either in the form of rule, regulation, or the notification by law as required by the Parent Act. There are a few examples of subsidiary legislation. First is Employee Social Security Supply Regulation 2006. 2 is Legal Aid Mediation Regulation 2006. Third is Section 601 of the Employment Act 1955. 4 is the Minister may by regulation provide for entitlement of employees to and for the payment by the employer of A. Termination benefit, B. Layoff benefit, C. Retirement benefit. The Minister made the regulation known as the Employment, Termination and Layoff Benefit Regulation 1980. They are the process to make subsidiary legislation.
Hi, my name is Normanina binti Abdul Karim and my number metric H2182363. For B part, we do underwriting law. First, we have English law, and second, we have judicial decision, and the third, we have customary law. Okay, next my part is English law. The law of is mainly based on the common law legal system. That means English law forms part of the laws of Malaysia. And the next, in Article 160 of the Federal Constitution states the definition of laws, which includes the common law in so far as it is in operation in the federation or any part thereof that concerns the extent to which the English law is applicable in Malaysia. The application of English law in Federation of Malaysia. 3 distinct laws. It is the Civil Law Ordinance 1956 in Peninsular Malaysia and the application of Laws Ordinance 1951 in Sabah. Alright, next, the application ordinance in 1949 in Sarawak permit the use of English laws. And the Civil Law Ordinance Extension Order 1971 expanded the application of the CLO 1956 for Sabah and Sarawak. Alright, next, the following 3 sections. It is Section 3, Section 5, and Section 6. Specify to what degree English law of shall be applied. Alright, next we have 3 sections. It is West Malaysia, Sabah, and Sarawak. First of all, West Malaysia apply the common law of England and the rules of equity as administered in England of 7th days of April 1956. Alright, now Sabah apply the common law of England and rules of equity together with statutes of general application as administered or in force in England on the first day of December 1951. Next, Sarawak applied the common law of England and the rules of equity together with statutes of general application as administered or in force in England on the 12th day of December 1949.
Is judicial decision. These are the decisions made by the superior court such as Federal Court or Court of Appeal and the subordinate court like Section Court and the Magistrate Court. These decisions are part of Malaysian law and are made and followed by Malaysian court under the doctrine of binding judicial precedent. The doctrine of binding precedent is applicable when the decision of case law bind the immediate party to the decision or proceeding. Then the judge does not decide case arbitrarily and follow principle or decision made by judge previously in similar situation. The binding of principle based on the hierarchy of court. The general rule is the decision of higher court, bind lower court, and some court are bound by their own decision. Here the hierarchy of court in Malaysia.
So today I would like to present about customary law. Customary law or adat in our Malay term is under unwritten law that are found in a particular place where is no rules enacted by legislative authority. Next, customary law or adat consists of a set of unwritten law or rules that have been enacted by legislative authority or formed as in the case of current legislation. Next is customary law. So we have custom practiced by local people. So custom relating to family law are given legal force by courts in Malaysia. Take for example marriage, divorce and inheritance. So in Peninsular Malaysia, we have adat pepatih. So Malays in Negeri Sembilan and Naning in Melaka, such as land and election of rulers. Last but not least is adat Temanggung. There are many states such as from Palembang and Sumatra.
Next, Islamic law. What is Islamic law? Islamic law refers to juristic interpretation faith of defined law Sharia. Muslim legalities refer to either state law where Muslims are majority or minority or the legal practice of non-state Muslim communities. So we have four types of Islamic law, which is Hanafi, Shafi'i, Maliki, and the last one is Hanbali. So Islamic law includes family matters and estate matters. So for family matters, Islamic Family Law Federal Territories Act 1984 and Act to enact certain provision of the Islamic family law in respect of marriage, divorce, maintenance, guardianship, and other matters connected with family life. Family matters divide by two, which is marriage and divorce. Marriage, a legally and socially sanctioned union, usually between a man and woman, that is regulated by laws, rules, custom, belief, and attitude that prescribe the right and duties of the partner and accord status to their offspring. And for divorce, to end marriage with one spouse by divorce, to cancel the marriage contract between two spouses, to make or keep separate, disunite, and divorcement. Estate matter. Estate law is a subcategory of property law which governs the manner in which a testator's estate is handled. These include overseeing how the individual's property is managed during their lifetime as well as after they pass away or become decapitate. So the estate matter divide by two, which is inheritance and wasiat. Inheritance is defined by the Distribution Act 1958 and the Inheritance Proliferation Act 1971, both of which lay out the condition of inheritance. Civil law allows for the personal wish of an individual to dictate the ownership of an estate upon their death through the use of a will. The next one is wasiat. Wasiat is a declaration of a person made during his lifetime with respect to his property or benefit to be carried out for the purpose of charity or for any other purpose permissible by Islamic law after his death.